Thank you. 2 minutes.
2 minutes. Okay. You may proceed when you're ready.
A little timer here. May it please the court. I am very grateful to be here and have the opportunity to set our case, the McDaniel matter, in the context of the very significant judicial, one could call it, a significant attempt to make a new start or set a new standard for the admission of 404B evidence. And this court, in its McConnell decision, of course, and since the submission of the briefs in this matter, the Ohio Supreme Court in Hartman have done precisely that, and have made significant strides, I think, in dealing with what, frankly, every practicing trial attorney understands is the resident abuse of the 404B standard. I mean, frankly, from at least from the perspective of the defense attorney, what this has been in the past in far too many courts and far too many jurisdictions is a situation in which all the prosecutor has to do is to chant the magic words, to recite the incantatory phrases of the 404B exceptions, and boom, it's in.
Well, except in this case, this came in by virtue of really defense counsel's questioning, asking the witness, is there anything else that disturbed her or bothered her about your client? And I mean, I frankly don't see how that answer was going to be anything positive for your client. But that's the record that we have here.
I agree with the court. That was sloppy cross-examination. I do not think that Mr. Bastian opened the door so much as he was standing too near the door when the victim out-lawyered him and hit him in the face with the door. And when he tried to pick himself up, she hit him again. I think with regard to the opening the door issue, there has to be, at least on the part of the defense, a strategic advantage that's contemplated by opening the door to other acts evidence, and I just think that the defense counsel here, I certainly agree with the court. He ought not to have been surprised, but he was, and I just don't think. I don't think that kind of frankly sloppy trial lawyering is either opening the door or ineffective assistance. It's just sloppy, and I with respect, I really don't know that. I know that's what the trial judge said specifically, that okay, you opened the door, and that's why I'm letting in the other acts evidence. But again, with respect to the trial court, I think there was just an excuse. That other acts evidence was coming in, and it was coming in merely because the prosecutor mouthed the incantatory phrases, which in actual fact, his explanation of why Mr. McDaniel's prior misdemeanor convictions for exposing himself showed absence of absence of mistake.
Was there any information, because I did take a look at the trial transcript, but I know this was litigated pre-trial, right, in a motion in limine?
Precisely.
So I didn't see anything at trial that talked about what exactly happened with the prior convictions. It was simply that he had these prior convictions. Is that correct?
Correct. There is no explanation. In Justice DeWine's opinion in Hartman, he makes some very good suggestions about resetting the other acts admission standard. One of them is that besides giving the standard curative instruction, the trial court ought to explain to the jury in plain, simple language, in context, why the other acts evidence was admitted. And had the trial court been required to do that here, it would have been tongue-tied, because in the pretrial litigation, in that first pretrial conference, the prosecutor tries to explain why the prior convictions of the defendant show absence of mistake, and he says, well, it's because he was on probation, and therefore he was on notice not to do this naughty stuff again. That was his explanation for why the priors showed absence of mistake. Later in the hearing during the trial, when this came up, as all the parties seemed to understand that it would, one way or another, the prosecutor gave an entirely different explanation. He said that, well, you have the clients, the defendant is claiming mistake in the current offense charged, where he didn't really mean to tape the victim in the shower. He meant to to record his own girlfriend by consent. But he also claimed mistake before, and that's never explained what the prosecutor means by that.
That's where I got hung up, because I did take a look at the trial transcript and I didn't see any details about his prior conviction, so I didn't understand.
There isn't any, and there's nothing to understand, because the state provides no understanding of why it offers that contradictory and equally ineffectual application of the 404B exception.
Well, Mr. Kent, let's assume you're right, and that was a violation of 404B. How do we evaluate harmless error in light of the testimony of the victim?
Well, I addressed it as best I could with my assignment of error as to the evidence. I am deeply impressed, and I am attempting to answer your question, Judge Bergeron, with the trial abilities of the victim. I think she mopped the floor with the defense counsel. If you look at her background in this case, what the evidence that we do have tells us is that she objected to her friend's relationship with McDaniel. She wanted to break it up. She and she may have used this incident to do so. She had a motive. She knew what she was doing. There is ambiguity as to who knew what about who was using the bathroom when. It's an almost impenetrable three-way domestic situation. And
so just on the harmless error piece of it, though, so the prosecuting witness blurts out these prior bad acts, and part of the relief the defense counsel was asking for was to strike her testimony. And then I believe the judge then said the door's open, and then all of the clerk's office certified records come in. But the jury already heard this information, and so that, I think that's the question, is how then the defense counsel brought this in. It was inartful questioning, certainly, but the jury heard it. So how do we say this was not harmless?
I think this is a situation where it's the 404B, the new 404B standard that's at risk. And again, and I understand completely the court's concern with an inelegant trial record, for which I cannot apologize or make excuses. But the fact is that there is no justification for those cases coming in. I think,
Mr. Katz, I'm sorry to interrupt you.
Not at all.
Let me ask you this. And this is following up on Judge Bergeron's question. Just assume, for the sake of argument, that it was error on the part of the trial court to admit the 404B evidence when the court did. But at that point, the prosecuting witness had already mentioned the prior convictions. But then, as a defense, which I know Mr. Katz, you would never use, it was brought out a third time by the defendant. And as far as I can tell, the defense was, it was a mistake. That's why I'm having a trial today. The two prior convictions were not a mistake, and I took responsibility for them. So it was brought out a third time, I guess, as a defense, in essence saying that, you know what, we wouldn't be having a jury trial here today if I were guilty of this, and it was a mistake. So how do you address the fact that essentially these prior convictions were brought out twice by defense counsel during the defense?
From the standpoint of defense strategy, it's sort of like an old Buster Keaton movie where he's an ambulance driver, and he hits the victim, and then the victim slides out the back door, and then he backs over him. I can't defend it. I hope that if the court decides it's harmless error, it will also assess the error in context and use it as another opportunity to provide the kind of principled judicial standard that we desperately need with regard to the.
And Mr. Katz, you're at your time if you want to reserve 2 minutes.
Thank you, Your Honor.
Mr. Donovan?
Your Honor, there's a an initial matter, I would point out that the Hartman case that defense counsel was speaking about is not part of the briefs, was not supplemented as part of the briefs, and is not properly before this court. It came out in September. There was plenty of time to have made it part of this and to have prepared the state for responding to anything that is possibly contained in that. However,
well, but I mean, you can't expect us to ignore a controlling Supreme Court decision on the exact standard that we're arguing about.
Your Honor, no, certainly not if it creates a new standard. However, you can't spring cases on the state at oral argument and expect me to be able to address what is contained in that case. I've had no notice and no warning that this was going to happen.
Mr. Donovan, I understand, like, if this was some case from Kansas or something, but this was a watershed decision from the Ohio Supreme Court that certainly your office is well aware of. And I mean, I don't see how you're being prejudiced by having to address the standard.
Your Honor, I'll move on. It's not a big point because, you know, even in speaking about Hartman, Mr. Katz hasn't said how it changed or how the trial court violated Hartman. Nothing has changed. The standard hasn't changed. There's nothing new about what the trial court's decision was. Invited error has always been a part of jurisprudence in terms of 404B.
Was this proper evidence to be admitted under 404B as absence of mistake?
In my review of it and the arguments, the trial court did determine that it wasn't simply that he was on probation, that he had to follow the rules of probation. There were additional arguments that were made in the lengthy liminal hearing that was held pre-trial. And all of these, I believe it was 67, 70 pages worth of the transcript that this hearing's had. And then consistently throughout the proceedings, it kept being revisited and the arguments kept being made that defense counsel was going to argue that it was a mistake, that it was an unintentional act. And I think part of the confusion.
But I think Judge Krause's question is, was that accurate? I mean, was this legitimate absence of mistake evidence under 404B?
And Your Honor, I understand I'm taking a lengthy time to answer the question. However, I was arriving there shortly. I think that a lot of what the confusion is people using interchangeably the word accident and mistake. Defendant was saying that the prior acts were a mistake. They were intentional, but it was a mistake that I made that decision, and saying that this was an accident. What the state was arguing was that the prior, it's a pattern of similar cases. Certainly that the priors were not for voyeurism, but they were for other sexually related and interrelated cases. And so the argument was that it was substantially similar. However, whether or not ultimately that decision would have been appropriate isn't truly before the court, because the door was opened, the priors were revealed on direct examination, and now under invited error, they can't claim prejudice. So my argument is twofold. One, we don't reach that decision because of the door being open, but two, even if we did, that it's not simply to say that he was on probation, as Mr. Katz argued. There was much more to the argument that was involved in the liminal hearing, and that supported the absence of mistake. As we all know, that the liminal decision wasn't binding. In order for the state to have gone down that path, the foundation would have needed to have been laid, would have needed to have waited until the absence of mistake or the defense of mistake had been raised, or the defense of accident had been raised. Then and only then could the foundation have been laid. We kind of jumped the gun there, so we don't know whether the state would have ever been able to lay that foundation.
So are you arguing that even if maybe this was improper evidence to bring in, it was still okay to bring in because the defendant opened the door. Is that the argument?
Even if they ultimately would have been unsuccessful in bringing it in the state's, I think it would have had to have been in through rebuttal witnesses is how it would have had to have come in. Even if ultimately they would have been unsuccessful, we never reach an analysis of that. It's speculative as to whether or not the state would have been successful in that, given that the door was opened prior to that. Does that answer your question?
Well, I mean, you're saying that we don't need to make a determination of whether the judge abused her discretion in admitting this evidence, whether it was propensity or proper 404B evidence, right? We don't need to go there because the defendant opened the door.
Not exactly, Your Honor. But I am glad that you raised that point, and that was one of the next points that I was going to say, is that the question is not, and contrary to what is being argued, there's no new standard that is being revealed. The standard is still that it has to be relevant, that it has to be offered for a legitimate purpose, and that the danger of prejudice must substantially outweigh the probative value. That is still the standard. And for this court, it's to review whether the trial court abused its discretion in making that determination. It's not whether or not we would agree or you would necessarily agree, but whether the trial court's decision was unreasonable, arbitrary, or unconscionable in making that decision. And I think that the lengthy pretrial, including the proffer of the roommate's mother, in which the trial court said, yeah, no, you can't talk about that. That's not proper. That's not coming in over 404B, indicates that the trial court was doing an individualized basis and an individualized determination on this. I'd also like to come back to some of the questioning that you were doing, Judge Krause, about the details of the priors. The state was specifically told and specifically agreed not to talk about the details of the priors. That was something that was discussed at the liminal hearing. That was something that when the records of the prior convictions were coming in, that was specifically requested that the affidavits and anything containing the details of those priors be stripped out, and that it was only the fact of the conviction, the charge, and the method of conviction, that it was a guilty plea, was the only thing that was to remain in there. So the lack of details was ordered and negotiated in terms of that, and that's why there are no details in the transcript as to what happened in those prior cases. But beyond all of this, and even if, and this will go back to Judge Bergeron and I believe that all three of you have touched on this, is the harmless error determination. Even if the court was wrong in ruling that defense counsel had opened the door, and even if that evidence was admitted improperly, we must look at the strength of the evidence, the other evidence that as to the conviction, and the strength of the other evidence, we would argue is fairly overwhelming. The concocted after the fact excuse that it was it was a prearranged thing that the victim the roommate, the girlfriend, takes an hour-long shower, and that they had agreed that they were going to record that, and that he put the phone. Well, there's no need to hide the phone. The victim wasn't going to be taking a shower. So this is an agreement, and she knew prior to him going in and putting the camera in there, because it was done after the victim had texted back and forth with her about, can I go to the bathroom before you take a shower? I'm not taking a shower. It's the text response. That happened prior to the defendant going in and setting up the camera. So it was known before that. The fact that the camera, the defendant wants to say he never saw it. He never viewed the video. The fact that the camera stops the moment after she gets done. And the moment after she's finished with the shower, he says, "Oh, the camera must have died." That's awfully convenient. And you know, if we're to believe this, there's no explanation as to when did you go back in? Why didn't you go back in to get the camera? Oh, well, I just forgot about it. It's just something that we always do. Well, it's not something that you always do. The testimony was that it was something new. And so
his girlfriend actually substantiated his testimony, though, right?
In parts, they both testified that they had previously taken videos of themselves to send and pictures of themselves to send to the other one. He said that they always deleted it within a couple of days. She said, no, we kept some of them for months or even years afterwards. So there's not a complete substantiation on that. But what they did, what they did both say was that this was going to be the first time doing something like this.
Well, did she substantiate, remind me, did she say that, yes, they had that discussion about taping her in the shower that day to substantiate what he said?
Not specifically in reference to that day, but does say, my recollection is that there is no specific timing as to when that conversation allegedly happened, but that she did substantiate and say, yes, I agreed to this. And
was that for the first video or the second one?
It was for the first video, and I'm glad you brought up the second video. The second video belies and impeaches the veracity of the claim that it was to film her. She, the victim comes in and finds the camera. The roommate, the girlfriend's not even there. There's absolutely no reason for there to be anything like that going on. The jury,
but there wasn't actually. But part of the problem with that, though, is there wasn't actually a second video, was there?
We never had it in our possession. The victim testified that she saw the camera recording. The defendant said, I never turned on the camera. I don't know anything about a second video because, I never knew about it. So why would I know that? He testified. That was his testimony. The girlfriend had said that she went through the recently deleted files, but as the testimony says, that can also be, you can delete the recently deleted, and so there's no evidence of it. So you are correct, sir, that the testimony of the victim is the only corroboration that we have that a second video was happening, but it is consistent with her reaction to finding the camera again, finding the hidden camera again in the same spot in the bathroom. Her reaction to that and the subsequent discovery of the January 3rd video is consistent with it. But no, sir, there is no physical copy of it. It was never presented to the police, and it wasn't presented at trial. All of this was presented to the jury. And as the court is well aware, the jury was free to agree, disagree, believe, or disbelieve anything that they wanted. And through their finding of guilt, they clearly believed the victim's version of events and did not believe the defendant and his witnesses' version of events. And I think that
this was a credibility case, basically. It came down to who the jury was going to believe.
Right. There's no question of identity. There's no question that he recorded the video. The question is whether or not we believe that 4 days later, after he had set up the video to take video of his girlfriend, that he never looked at his phone, that he never checked the videos, that he never deleted checked to delete. Oh, she didn't take a shower. I should go in and I should delete that video. That he never gave it a second thought until he was confronted with it. The jury was free to find that incredulous, and through their verdict, did. And so we would say that even if the 404B determination was in error, and we go past, we say that she shouldn't have been allowed. She should have stricken that testimony, and you remove all of that from the equation. There's still a substantial amount of evidence that the defendant did in fact commit this crime, and there's no indication that the jury lost its way or was unfairly or prejudicially impacted by names of a charge on a piece of paper without further detail. And so to that, and the one other thing, because I don't know what's going to.
Well, you're at your time, Mr.
Well, then there will be nothing more.
Thank you. Mr. Katz, you have 2 minutes.
Thank you. Briefly, in weighing the evidence with regard to harmless error, I'll just say I hope that the court will keep in mind the possible importance of the motive of the victim in pursuing this prosecution. There is even a record of before she went to the police, the victim bargaining with her friend and landlord about, well, if you break up with him, with McDaniel, I won't go to the police. The victim is very much in charge of this prosecution. I'd like to use the rest of my time to assert my agreement with Mr. Donovan about my calling it a new judicial standard. Of course, it's not. I misspoke. What Hartman and this court's decision and McConnell establish, I think, is a reification, an actualization of that standard, a vigorous reference back to foundational texts and foundational authority about how 404B exceptions should really work. Let me close simply by referencing the prosecutor's term in the case at bar, which I think is a brilliantly descriptive way of sorting out what it was, the sort of the magic words theory of why 404B should come in. Mr. Prem summarized his presentation to the court pretrial conference by saying, the reason these prior acts should come in, Judge, is because they're all charges that come under the canopy of sex crime, and indeed they are. And that's the justification. If the charges come in under the canopy of sex crime, it's other acts evidence that ought to be admitted. And that's, of course, exactly descriptive of the state's strategy in Hartman, in McConnell, and in this case. And it's the court has made a true and important statement for maintaining true fairness of trial in its McConnell decision.
Yeah, thank you, Mr. Katz.
Thank you.
Thank you both for your arguments this morning. The case will be submitted and we'll get out a timely written decision. I hope you both have a nice day.
Thank you. Thank you.
All right, our next case is State versus Jackson. Welcome, Ms. Nelson, Mr. Sauter. Ms. Nelson, how long would you like for a rebuttal?
3 minutes, please.
3 minutes. Okay, you may proceed when you're ready.
Good morning, Your Honors, and good morning, opposing counsel. May it please the court. My name is Sarah Nelson, here on behalf of Mr. Jackie Jackson. This case concerns the trial court's error in overruling Mr. Jackson's motion to suppress. The state carries the burden to demonstrate that the stop and search of Mr. Jackson's vehicle was constitutional. They have failed to meet that burden because no officer testimony was offered in this case, and the body cam video standing alone does not support that the stop for a window tint violation was lawful, and that Mr. Jackson's removal and the subsequent search of his vehicle was in any way pursuant to officer safety. Furthermore, without testimony from the officers to support an officer safety search, then the state can't meet the plain view exception because they haven't established a lawful right of access to the vehicle's interior.
And was the defense challenging below the probable cause to stop the car for the window tint violation?
They did challenge it in their motion to suppress. I recognize that the state had pointed out, and defense counsel did say on the record that I'm not questioning the stop and that officers can make reasonable mistakes, but I don't necessarily interpret that as an affirmative waiver of the issue because of the fact that it was raised in the motion to suppress, so it was before the trial court. But even if this court construes it that way, we would encourage this court to consider the constitutionality anyway, because there is a presumption against waiver of constitutional issues.
Well, but I think the problem from the probable cause standpoint is you're complaining that they just tendered the video evidence, but if the defense wasn't raising objections to that, the state didn't know that they needed to do more. You see what I'm saying?
Yes, I completely understand. And this court could certainly find waiver in this case. But with the case law suggesting that there's a presumption against waiver, we would just encourage the court to consider that the video evidence was insufficient with respect to probable cause, mostly because the video evidence refutes any reasonable suspicion of window tint. When you watch the video, you can clearly see through his windows into the vehicle. So we would like to see officer testimony to support what facts and circumstances were known to him at the time. Not only that, but the trial court didn't make any specific factual findings on this issue. So we would just, again, encourage this court to determine for itself if the video could support that initial stop, because it does change the remainder of the analysis. Although, even if this court does decide that the issue was waived, there was still no testimony with respect to officer safety, which is the basis that the state relied on to search the interior of the vehicle. And we still need officer testimony.
Wait. I thought that they searched the interior of the vehicle because they found a marijuana joint.
But the question there is, how do we get to the interior? Because the joint was only visible because the officer himself, not Mr. Jackson, the officer opened Mr. Jackson's door. The
door was open to get him out of the car. And then they saw the joint sitting there on the floorboard, right?
Correct, but it's the officer who opened the door. It wasn't a voluntary act by Mr. Jackson exposing the interior of his vehicle for the officers to observe the joint. The officer opened the door.
Before you get to that, I mean, are you saying that during a stop like this, that the police are not allowed to ask the defendant to get out of the car?
Well, first there has to be a lawful stop, but if we're past that, then officers do have authority to order a driver out of the vehicle, but it's my position that that authority is grounded in officer safety. It can just be a hunch that this particular defendant poses a threat, but there has to be more than just the actions of the body cam video. We need officers to testify what they were thinking in this particular circumstance.
Is that what the case law says? That unless there's an officer safety issue, they're not allowed to ask somebody to get out of the car when they're doing a traffic stop?
It's not explicitly stated like that. I think as it has evolved, all the officer needs is a lawful traffic stop. But again, ordering him out of the vehicle and detaining him is a authority granted to law enforcement for the purpose of officer safety. And if we, at any rate, even if we accept that, I disagree that they can just order him out for any reason whatsoever. I mean, again,
Well, Ms. Nelson, I know the officer requested your client provide a driver's license, and when he was in the car, he was kind of fiddling around, it looked like, with his phone. And are you saying that if your client doesn't produce the license, he may not be ordered out of the car?
Well, failure to produce a license could be a basis to detain somebody outside of the vehicle, but that's not exactly what happened here. Mr. Jackson was on his phone, but as he states later, his insurance information was digital and on his phone. And not only that, I mean, whether he produces his driver's license or his insurance information first, I mean, he had both at the end of the day in this case. So it wasn't an issue of being detained for failure to provide the driver's license. And again, and respectfully to the officer, he sort of unfairly jumped the gun here by, I mean, it was a matter of seconds. It wasn't just like a long delay of not being compliant to the officer. It was pretty immediate. If you're not going to produce your license and insurance, we're going to be getting you out of the car, and no more than a second or two passes before he acts on that authority. But again, the question to, observing the joint in the vehicle, it was tucked in between the side of the seat and the side door paneling. That is an area of the vehicle that would not be open to view, but for the officer opening the door. If Mr. Jackson had opened the door to comply with an order to get out of the vehicle, then that's a different case, but that's not what we have here. And it's our position that the officer—
Well, wait, I guess I don't understand how that's different. If he's being ordered out of the car, why does it matter if he opens the door versus the officer opens the door?
Mr. Jackson opening the door is more of a voluntary act exposing the interior of his vehicle. If that is what happened in this case, then he subjects the interior of his vehicle to be open to inspection via the plain view exception. That's what gives the officer the lawful right of access. The officer doesn't have a lawful right of access to view certain nooks and crannies in the vehicle without a threat of officer safety or some other articulable suspicion of something in the vehicle, none of which we have in this case. So when the officer opens the door, he creates an unfair advantage, he creates the vantage point for himself to view that joint, particularly where it's placed. This isn't an instance where, it's an open view in a bag on the top of the seat where you can peer in from the window. That's a different case. So it is, in our view, very significant that the officer was the one who opened this door in this situation. It's pivotal and detrimental to the state that there was no officer testimony to, again, tell us what factual circumstances were relevant to give them any fear of officer safety or that my client was in any way armed and dangerous. And that omission on this record is where the state's case fails. They can't prove a lawful right of access to the interior of the vehicle, and therefore they can't meet the plain view exception because that's a necessary element.
But going back, I thought you said that the search occurred for some other reason than the fact that they found the joint.
Yes, it was the state's position at the trial court level that this search was always pursuant to officer safety, and then the joint was viewed in plain view. So in order to get back into the vehicle, you have to have a lawful basis in officer safety. That's our position.
So the state was saying that they found the joint while conducting a lawful search. Is that what you're saying?
Yeah, so that was my impression of their argument, was that they were conducting a lawful officer safety search. And again, we're refuting the lawfulness of the officer safety search. And pursuant to that search is when they found the joint in plain view.
Okay.
I didn't understand that. Because I did look at the body camera video, and I saw the officer who found the joint, and I guess what I thought happened, and I mean you're correcting me now, is that he saw the joint, and then because of that they started searching the car.
Again, we need officer testimony to sort of help us in the chronological steps here, but I think this all goes back to the officer opened the door and created that vantage point. That is where the search starts here. And in order to get into the interior, we have to have officer safety, which is why I believe the state relied on an officer safety search in order to get the access to the interior. If Mr. Jackson had opened the door, completely different case, but that's not what we have here. If there are no further questions, respectfully, I would like to reserve the remainder of my time for rebuttal.
Thank you very much.
Thank you.
Mr. Sonner?
Good morning, Your Honor. May it please the court, counsel. First of all, as to the waiver issue about the stop, this isn't a situation where the issue was just not raised at all. This was at page 13 of the transcript. The issue is affirmatively abandoned by defendant's counsel, and I think to revive the issue at this point would be unfair to the state. I think that is an issue that's been taken care of at the trial court level. As for ordering Mr. Jackson out of the vehicle, the upshot of Mims and his progeny is that a traffic stop is inherently dangerous to an officer. The discussion Mims at 434 U.S. at 110, it talks about the dangers of assault from the occupants and the danger of passing traffic, just to name two things that the court identified. There's no requirement that the states separately show particularized danger to the officer under the circumstances of any particular case. The Evans case and in cases following that dealt with further investigation, such as a pat down or cuffing the defendant, putting him in the police cruiser.
So can you help us out? Were the officers conducting some sort of what was the search that they started? Was it an investigatory stop related search of the vehicle, or did they start the search once they saw the marijuana joint?
Yeah, I think from the video, it's clear that there was no search before the discovery of the joint at the side of the car. One of the officers was, happened to glance down, sees the joint, and that's when the search of the car began. Nothing happened before that. The only thing that happened before that was the removal of the defendant from the car, and that was justified under Mims and Evans. Even if the state.
So let me ask you this: like, if the joint had not been visible, had the door been closed, is there any conclusion we should draw from the fact that the officer opened the door and then failed to close it?
I think this triggers the whole plain view analysis with the door being open. I just don't understand the distinction between the officer opening the door, the defendant opening the door, whether or not the door.
No. My question is the door being open versus closed. So let's say that the joint is not in plain view. If you're just on the exterior of the car looking in, but the door is closed and it obscures the view of the joint. But once you open the door, it does become in plain view. So does the fact that the door is open or closed, does that have any legal significance?
Well, yeah, the opening of the door is what creates is what allows the joint to be in plain view. So yeah, I think that's the crux of the matter, is that the officers had properly opened the door, and under Wilson and Akoff, they were justified in doing so, and their positioning after the door was open is what created the plain view nature of the joint at the side of the car. So yeah, it's definitely an important distinction, but I think I think under Mims and all the other case law cited in the state's brief that it was proper for the police to do so. The question about the dangers to the officers, as I've already stated, I think the upshot of Mims is that there is no requirement of particularized danger, but if there were, in this case, the defendant refuses to show his license. He's not belligerent, but he's definitely recalcitrant. He's questioning the officers, why am I being stopped, instead of complying with their orders. And I think that gave a full justification for the officers to further investigate the matter and to take him out of the car, to do whatever they needed to do to ensure their own safety. And again, the plain view doctrine is met here once we reach the conclusion that the door was properly open, and I think we can. The joint was readily apparent from the side of the car. The police cam the body cam indicates that all you had to do was look down, and it was didn't require any manipulation of a seat or any of the other contents of the car to see this. It was readily apparent from the side of the car. And once the joint was found under the automobile exception as set forth in Wilson, Hamilton, and Akoff, the police were justified in searching every portion of the vehicle. And I just don't think that that there's been any demonstration that there was any impropriety in the case.
Thank you, Mr. Sauter. Ms. Nelson, you have your rebuttal.
Thank you, Your Honors. I would just like to reiterate that I think the officer opening the door is significant and does constitute a search in this case. It unfairly, to Mr. Jackson, unfairly puts the officers in a particular advantage to view this joint that otherwise wouldn't be visible. At the risk of repeating myself over and over again on this point, I will respectfully submit on my briefs unless the court has any other particular questions.
All right, thank you both for your arguments. We appreciate it. Case will be submitted. We'll get out a timely written decision. Have a good day.
Thank you, Your Honors.
Thank you.
Good morning, counsel. I'd ask you to help us out and just introduce yourself and tell us which party you're representing.
Francis Barrett with Josh Good on behalf of plaintiff appellant Dr. Cranbury.
Okay.
Good morning, Your Honors. It's Mike Roberts on behalf of the Brenda Moore appellants.
Yes, and Your Honor, Scott Phillips on behalf of the Indian Hill, one of the appellees in this case.
And Tim Burke on behalf of the Cat's interests, and I will be joined by Kathy Ryan, the associate, who's been with me throughout this matter.
Okay. And so for the appellants, how do you intend to divide time this morning?
Your Honor, I will start off. We want to reserve at least 5 minutes for rebuttal. I want to take just a few minutes, then I'll let Mr. Roberts argue.
Okay. And Mr. Roberts, you'll take the balance of the time?
I'll probably go right after Fran and then take the reply as well. Correct.
Okay, so how much time do you want for the rebuttal?
I think that Fran said 5. We're allotted 15 between us, correct?
Yes. Yes.
Yeah, so 10 divided and then 5 with me at the end.
Okay. All right, and Mr. Burke and Mr. Phillips, how do you intend to divide time?
Your Honors, I'll start first with just a few minutes, probably no more than 5, and then turn it over to Mr. Burke.
Okay, I will do my best to keep track of everybody's time.
Thank you.
Mr. Barrett, are you ready to begin?
Yes, may it please the court, on behalf of Dr. Cranbury. Dr. Cranbury has lived on Holly Hill for over 40 years, since 1978. Our understanding from day one has been that this is a non-conforming lot adjacent to her. And she's also she's a very intelligent person. She's specializes in radiation oncology. She's on the staff of Christ Hospital as Dr. Weichert for over 40 years. And really, quite frankly, it's been an insult to her intelligence for Indian Hill to say this is a conforming lot. If this were a conforming lot, we would not have had to go through this entire exercise. It's non-conforming because it does not meet required lot frontage. The definition of lot frontage could not be clearer. The zoning code states, quote, the greater of the following 2 distances. It says 2 distances, not 3 distances, 2 distances. Either the length of the front lot line or the length of a line substantially parallel to the front lot line at the required least front yard depth, not the actual front yard depth, but the required front yard depth. The front lot line in Holly Hill is about 74 feet. The required setback, the required least front yard depth in the zoning district, this is zoning district A, a 5-acre zone, requires 250 feet of frontage, and the required least front yard depth is 100 feet. Going back 100 feet is about 74 feet as well. You have to go back to where the house is located over 600 feet to have the sufficient frontage or sufficient width. And that's exactly where the trial court and the magistrate went astray. It's not where the house is located. Lot frontage is determined on the plotting of a lot, not where the house is located. The definition of front yard least depth is simply the measurement of the distance between the front lot line and where the principal structure is located. On the definition of yard in the zoning code, it's open space. You have a front yard, a side yard, and a rear yard. You must meet those setbacks. So in order to determine whether the setback is met, you have to have a definition of the measurement. You have front yard least depth, and you have rear yard least depth, and you have side yard least width. For some reason, the property, the Cons and Indian Hill argued successfully to the trial court that it's the actual placement of the house that determines whether you measure it. That's not what the code says. It's frontage. It's not lot width.
Well, but what about the rear yard? Because the as I understand it, the line that you and Mr. Roberts would propose creates a yard behind the rear yard, essentially, based on the configuration of the lot.
The way the Indian Hill zoning code is written is to realize and recognize situations like this. So the code says you have a front lot line, and the lot line, which is generally opposite the front lot line, is the rear yard line. So if you have an irregular lot, what Indian Hill and the Cons argued here was it's a line which is farthest away, and it's not farthest away. That becomes basically a meaningless setback. The point is to have the front lot line have a 100-foot setback and the rear yard line have a 100-foot setback. And the two are basically opposite each other. As the magistrate correctly noted, the lot line, which is farthest away, first of all, the zoning code does not say farthest, it says generally opposite. They added the word farthest. But as the magistrate's decision points out quite well, that lot line, which is farthest away, is not opposite. It's not facing, it's actually off to the side. So it doesn't meet the definition. Again, the point is in the Indian Hill zoning code is to have a situation where you're addressing irregularly shaped lots. And as our expert,
right? But I mean, that makes sense if you have a nice square lot or rectangular lot. But when you have a bizarre shaped lot like this, why shouldn't we be deferential to what the zoning commission concluded?
The reason you should not be deferential is because standard of review is where the interpretation or application of the zoning ordinance is reviewed de novo. That's exactly where the trial court went astray in our opinion. The trial court deferred to Indian Hill. There's no deference whether it's a statutory or ordinance interpretation. The interpretation or application of an ordinance is reviewed de novo. There's no deference whatsoever. So you have to look at the plain meaning. This is a plain meaning case. And the plain meaning of the code is the rear lot line is one generally opposite. There's only one lot line which is generally opposite. That's the one that the magistrate found. It's just that simple, Your Honor. I'll defer. I think I've taken 5 minutes, so I'm going to defer to Mr. Roberts.
Okay, perfect. Mr. Roberts.
Thank you, Fran. Thank you, Your Honor. I'm going to go. As you know, there's a couple diagrams in the brief, and I'm going to try to complicate this a little bit by showing you the diagram with a share con.
I'm sorry, Mr. Roberts, you're trying to show us something?
Yes, if I could. So this is a diagram in my reply brief, I believe, if the court can see it.
No, we can't see it, but we have your reply brief. So why don't you tell us the page?
Well, let me move on. It's in the reply brief. It's the first diagram that's exhibited. I think it's diagram 1. But the analysis for your 2 questions, Your Honor. First, your question, why not be deferential? I think as a matter of law, as Fran answered, there is no deference that can be afforded if there's no ambiguity. And I would submit there is no ambiguity in the definitions we're talking about front lot line, rear lot line, side lot line. And so because there is no deference and you just apply it the way it is. Now, I understand in common parlance, your side yard is to the side of your home, but we have to go by what the code says. And the code has a 3-step process. You decide what the front lot line is. Notwithstanding a year of some debate about that and the creation of a fiction that the front lot line was on Park Road instead of Holly Hill, it's now undisputed, it's Holly Hill. Once you have that assigned, You then take the next step. The next step is what line is generally opposite the front lot line.
Well,
That's it.
so then that's my question. If we agree with you, what do we do with basically the back half of that lot that is behind the rear line?
Right. You don't, just common understanding of the lay public. You rely on the code. And I had this quote in my brief about the examination I took of Mr. West is instructive. I asked Mr. West. Now, Mr. West is the only expert who testified. He is the staff for this purposes. He looked at this repeatedly over several years, and his opinion was always consistent. And what he told me is, yes, Mike, you're right. You can, under the code, have a side yard that happens to be further away from the front lot line than the rear lot line is. That's the way it's written, right? And here's why. Front lot line, no dispute. Rear lot line, the line, singular, the line, generally opposite front lot line. Third definition, all other lines are side lot lines. It doesn't matter under the code whether a side lot line is further away from the front lot line than the rear lot line. It's inconsequential. I understand that's a little illogical for general understanding.
Let me ask you this.
Application,
Mr. Roberts, let me ask you this. In Mount Lookout, where I live, the houses are right on top of each other. It really matters, where the house is located. In Indian Hill, you've got much more of a buffer zone. So are you saying that no house could be constructed on this lot?
Well, that's a statement that the trial court judge made, and it's contrary to fact. There is plenty of evidence in the record that there are other areas of this lot where you can build a home. The problem is the cons came to this equation with a pre-designed home that they wanted to fit in that lot. There's plenty of area in the back.
That's my question, though. So if you agree that you could build a house on this lot, why does it matter to your clients that it's in one location rather than another?
Good question, Your Honor. And I think that kind of general sentiment controlled the decisions here rather than the code. The point is this: my clients invested between $8 and $10 million to build their house. They took that house, and when things happened in 2003 that are in the brief, in 2007, they relied on representations made by Indian Hill about what could and could not be done with that yard. And they built their home. They extended their home towards that lot for that purpose. And quite frankly, the rural atmosphere of Indian Hill is important, and they want the code applied as it's written. Now,
so the issue is really the size of the house that was being built.
Yes and no.
They didn't want any house. I mean, I guess that goes back to Judge Bergeron's question. I mean, are they trying to prevent any house, or is it just the house was too big?
They're not trying to present any house. They offered up, and this is in the record, they offered up options for the cons to build a home that wasn't significantly different, but at least complied with the code. By no means were they trying to prevent a home from being built there. They offered other suggestions that were rejected.
Okay. Mr. Roberts, if you'd like to reserve 5 minutes, you're at your time.
Thank you very much.
Thank you. Mr. Phillips?
Yes, may it please the court. Thank you. I find it amazingly ironic that we're hearing from counsel for the appellants about how this case is really involves legal issues. And then we hear, and we see in the record thousands and thousands of pages of facts that frankly are completely and totally irrelevant to the two issues that were presented to the Indian Hill Planning Commission and Indian Hill Council. And those two issues are very simple. The first is, how do you determine the lot frontage? Every body that's looked at this, from the Planning Commission to Council to the Magistrate to the Court of Common Pleas, agrees with the appellee's definition and interpretation of how you calculate that. And I would submit that that's purely a legal issue that either the court agrees with the other four entities that have looked at this, or it disagrees, but that's something that certainly is a legal issue. However, the rear yard issue is mostly factual. It really looks at kind of, when you look at the definition and you know what we've been spending years and volumes of paper talking about, is what does generally opposite mean?
And is it your position that that's ambiguous or no?
Our position is it is not ambiguous. Our position is that it allows counsel to use its discretion in making a determination as to if there are multiple possibilities, which one makes the most sense in the context of that. And that's in essence what counsel did in this case. When they looked at everything that was involved, obviously one of the things they looked at is which line is the rearest, if that's a word, which line is actually in the back of the lot. Mr. Barrett says that our position is that it always has to be the furthest one away. That has never been our position. Our position is in this particular case, looking at all the issues that went into it, the unusual nature of this lot, where the sidelines are in context of all of that, that the line that was chosen by Planning Commission and Council is the one that made the most sense. And they have discretion.
Let me ask you this, because this kind of plays into what Mr. Roberts was saying, which is if it is discretionary, then one day you might say, well, this is the rear lot line, and the next day you might say something different. And how does that give people who live in Indian Hill and are relying on that any certainty that the decision is going to be consistent?
Well, I think as Your Honor pointed out, the code is easily applied when you have a square or rectangle. In this case, you don't. And while there are some unusually shaped lots in Indian Hill, there's many lots that easily, are determined. So this issue doesn't come up. I mean, this is the first time I'm aware of an issue like this coming up. With respect to what we do, somebody has to make a determination in these type of cases. Someone has to look at all the context of what is happening and has to take into account how this is generally going to affect the community as a whole, as well as adjoining property owners. And most importantly, let's not forget about the person who owns the lot, who is entitled to due process, substantive and procedural. So from the village's point of view, the village looked at all that, it made a determination, and it ended up, I think, making something that made a lot of sense. Not that that's really the standard. The standard is did the decision that they make, as long as it's not arbitrary, capricious, or unreasonable, then the village council is entitled to deference. And frankly, they're the ones in the best position to make that decision. And when they looked at it, they picked a line that was 1, the most rear of all the lines, 2, the furthest from the front line, 3, behind all sidelines, 4, it created a lot with a large rear yard behind the home, and 5, it's the line that extends the width of the lot at that point, consistent with section 3912, which is the definition of rear yard. It was a common sense approach that took into account a lot of information that was presented, looked at the record as a whole, and they made a very well-reasoned decision, as evidenced by the fact that council reviewed hours and hours of testimony that was given in Planning Commission, allowed witnesses to testify again and listen to that, and reviewed thousands of pages of documents. In an instance like this,
and Mr. Phillips, you're at 5 minutes if you wanted to defer to Mr. Burke.
I will. Thank you, Your Honors.
Thank you. Mr. Burke?
Good morning, Your Honors. And thank you, Mr. Phillips. I agree with everything that you said.
Well, that's a first.
You're right. Almost 4 years ago, the Khans set out to build a home on this property at the end of an existing 600-foot driveway, essentially on the site where a prior house had existed but was burned down some years ago. It should also be pointed out as we begin that the proposed Khan's home is more than a football field away from either Dr. Craneble's home or the Brendamores home. And the record would reflect that even between the Kahn's proposed home and the Brendamore home, there's a buffer that was created to avoid the Brendamores having to see the prior home that was on the site.
So, Mr. Burke, what is driving this dispute? Is it the size of the house, or is it the location, or both?
I think it's a combination of both. And I think if Mr. Barrett's argument is taken to its logical conclusion, this property is unbuildable. Mr. Barrett will respond saying, well, they can apply for a variance. But the fact of the matter is Mr. Barrett's argument suggests this lot is unbuildable. And you're kind of reversing my argument on me, but let me deal with this first. What Indian Hill did when they determined what the frontage issue is the same thing they've done on a number of other properties in Indian Hill. We've cited and provide you diagrams with 6 of them in our brief. One is just 3 lots away from Dr. Cranebill's home at the end of Holly Hill. Same situation, narrower at the street, doesn't reach 250 feet at the street, at the front lot line, and it goes back, and it's something of a triangle, just as our property does. And the home is built where they achieve 250 feet of frontage. That's what the Kahn house is proposed to do. The rear lot line, and I think Mr. Phillips has done a good job of explaining that. We can look at the rear lot line, and the terms generally opposite create discretion. They also create some ambiguity, arguably, and from the Kahn standpoint, we believe there is some ambiguity there. But the fact of the matter is, when you look at the zoning code in paramateria, as I think everyone is required to do, the rest of the zoning code applicable to either of these arguments.
So if it is ambiguous, do we just defer to Indian Hill's interpretation?
I think that's absolutely right. Or the law requires you under Saunders to defer to the right of the Kahns to build their home. Zoning is in derogation of the common law. And where there is ambiguity, the decision goes to the property owner and the use they propose to put on their property. With regard to the rear lot line, you can look at either, you look, and we put it in our brief at page 19, the Brendamores expert who testified before the Planning Commission provided a diagram. And that may have been what you had in mind, Judge Bergeron, when you asked about what happens to the rest of the property. You'll see their expert's diagram showing where the rear lot line is in their view and what becomes of the rear yard. And that's part of looking at this zoning code in paramateria. Look at the impact of what the rear lot line does to where the rear yard is, and where the Brendamores propose as the rear lot line. It makes no sense, because it creates a situation where, in fact, both in a diagram they've attached to their brief, I believe in one of their appendixes 6, is a diagram showing a house partially built behind the rear lot line. And we've provided you in our brief a diagram that shows the house built entirely behind the rear lot line. That makes no logical sense. So when you look at the zoning code in paramateria, you look at the fact that the northernmost line is at Holly Hill. The southernmost line is the rear lot line we propose. That's the rear lot line that makes sense, because as Mr. Phillips said, that creates a backyard that's always going to be behind the house, no matter where the house is on the lot. It creates side yards that extend, as the zoning code said they should, from the front yard to the rear yard. To attempt to extend the side yards from the front yard to the Brendamores' rear yard requires you to go down the west side of the Kahn property and then circle back some 500 feet, going in the opposite direction to get to the rear yard. which puts 500 feet of the side yard behind the rear yard. That makes no sense. We have the same kind of in para materia issue with regard to the lot frontage. And in that particular case, as I've indicated, there are half a dozen, actually 7, that we cite to in our brief or the attachments there too. And Mr. Phillips indicated planning staff had added more when they did their staff presentation to the Planning Commission and to council that showed other lots similarly situated to this one, where the lot frontage was determined as it should be based on where the house is. Mr. Barrett relies on the language minimum lot frontage, minimum lot front yard setback. But definition of the minimum distance for the front lot, the front yard least depth, or the minimum depth, is the shortest distance measured horizontally from the nearest point of the principal structure to the front lot line. That's section 39-111 of the zoning code. Applying that definition of the least front yard depth, at that point where the con house is proposed to be built, the lot is 375 feet wide, more than complying with the lot frontage and meeting the second definition of the lot frontage contained in the zoning code. And again, this is not something that was invented for this lot. That's an application that Indian Hill has applied consistently to other lots, a number of which are in the record, and we've included 7 of them in our brief for you to see. We believe that this is a very clear case on both the rear yard and the front yard lot frontage issue. Only once in all of the decision makers who have looked at this has anyone disagreed on either of these issues, and that was the magistrate on the rear yard. Everybody else who makes decisions on this has been unanimous in deciding both issues in favor of allowing a single family home to be built on a 5-acre lot in Indian Hill. Thank you, Your Honors.
Thank you both.
Mr.
Roberts, Mr. Barrett, who's going to argue rebuttal?
I'll let Mr.
I will go.
I'll let Mr. Roberts handle most of it. I just want 30 seconds, Mike.
Sure.
I want to respond to the question, the pragmatic question that Judges Bergeron and Krause raised about the possibility of building any house on this lot. Dr. Cranville's position day one has been there's no problem building a house on this lot whatsoever. She had no objections whatsoever to the prior footprint that existed. This has to do with the setbacks that are involved. The point was made there's a football field separation with respect to Dr. Cranville's property and the Brennemore's property. That's because of the setbacks on their property. The proposed house is only 25 feet off Dr. Cranville's lot line, only 25 feet off the Brennemore's lot line. And this is a classic case of a non-conforming lot where it can be built with variances. The variances take into consideration the impact on the neighbors. And all of those examples, which are shown, the 6 or 7 examples, are all cases that are where variances were granted. They're not based upon the actual location. They're not based on the actual location of the house. Those were platted before the house was built. They're all approved by Indian Hill as a part of the platting process. And those are cases where the Planning Commission.
But Mr. Barrett, if your solution is to let them apply for a variance, I mean, you guys have been in litigation for how many years over this proposal? Like, what would a variance? I mean, wouldn't that just spawn a whole nother round of litigation?
It may, but that's the route they should go on. They should have followed from day one.
Okay.
Thank you,
Mr. Roberts.
Thank you, Judge Krause. Answering your question from previously, on page 7 and 8 of my reply brief, there are those 3 diagrams, and each of the diagrams show the location of a home in what's been called the pasture. So by no means are we trying to prevent them from building a home. The capacity to build a home exists. Let me offer some prepared remarks. This case is simple. It's simple all the way around, at least with regard to the rear lot line. All facts regarding the rear lot line determination are totally undisputed. If you find no fault with Judge Birding's analysis, you must reverse. It has equal applicability now as it did then. Here's why. The ordinance is unambiguous. The trial court judge did not say otherwise. If it's unambiguous, there is no deference given to village council. If it's unambiguous, there's no need to apply rules of statutory construction or Rule 1.49. Mr. Burke continues to argue in paramateria. That's his way of trying to create ambiguity where there is none. Sure, there is some limited discretion identified with the word generally. Judge Birding acknowledges that. She properly acknowledged that. There's limited discretion. There's no deference because it's unambiguous and the decision of village council is not supported by a preponderance of the reliable, probative, and substantial evidence. And here's why. Mr. West repeatedly came to one conclusion for that very reason. There is no reliable, probative, or substantial evidence in his expert opinion for any other conclusion. And I would offer this and conclude with this. In all where you have a line, Indian Hill admits this. It admits this factual concept. Indian Hill admits that the line we propose is, quote, exactly opposite. Indian Hill admits that the line we propose is directly opposite. Opposite deals with the concept of direction, not distance. And I would submit that in all cases, the application of these unambiguous terms of the ordinance require that when you have a line that's directly opposite and exactly opposite, in all cases, that line must be the line, singular in the code, that is generally opposite. The code does not give an amount of discretion to ignore what's exactly and directly opposite in favor of something that just happens to be furthest. And on that, I'd rest and/or invite questions of the court.
Thank you, gentlemen. This is very interesting, well briefed, and argued case. We appreciate your time this morning. The matter will be submitted. We'll get out a timely written decision. Hope everybody has a great day.